Salutations to all our future judges. In this video, we are going to see the Code of Civil Procedure 1908, Part 9, Section 35. If you have not seen the earlier part, that is Part 8, I am providing the link in the iCard. You can click that and watch Part 8. Then you can come and watch this Part 9. If you have not watched the earlier parts, that is from Part 1 to 8, I am providing the link of the playlist in the description. You can click that and watch all the parts. This would really be helpful to you. We are going to see section 35. Costs. The most important section in CPC is costs. The reason being, it is helpful in two ways. The first thing is, if you are a practicing advocate, you need to know when you should ask for cost in a case. Second thing is, during exams, they can ask questions from this particular section. So this section is very, very important, both for practicing advocates as well as for students who are preparing for the judicial exam. Now let us see about this costs under section 35. With respect to suits, cost can be imposed by the court, and that too, this is absolutely based on the discretion of the court. Let us move to the next point. This is the first point. Second point. The court will determine as to who has to pay this cost, by whom it should be paid, or out of what property it should be paid, and to what extent it is to be paid. So there are three things in this. The first one is who should pay, out of what he should pay, and to what extent he has to pay. Whom, what, and extent. These three are very important things. And to determine all these three things, the court should give a direction. If a person is taking a defense saying that the court has no jurisdiction to try the suit, then it shall be no bar to exercise such powers. To understand in a simple way, if a person is saying to the court, this court cannot impose the cost because this court has no jurisdiction to try the suit, whether this defense will work out? The answer is no. Even without a jurisdiction, the court can impose cost. Now let us move to subsection 2 under section 35. If the court is going to say that cost is not to be imposed, or the cost will not follow the event, in that case, the court has to record its reasons for saying so. This is 35. Subclause 2. Let us move to the next subclause. In this, there is a special thing which you need to know. If you have commercial disputes, in that case, the rules will differ. The cost will differ. That is given under section 35 as well. And it shall be applicable only for commercial disputes. Now let us move to the next subclause, which is subclause 2 under section 35. If the court has decided that it is going to impose cost, or it is going to direct a person to pay the cost, the general rule, generally what they do is, unsuccessful party has to pay to the successful party. Imagine, I am filing a case against A. I am successful. Then court will direct A to pay the cost to me. However, the court can deviate from this general rule, but it has to record the reasons. In the example what we took, I am successful. A, who is the opposite party, who is the defendant, has failed. But still, court can say that I have to pay cost to A under certain circumstances. It can deviate depending on the case. Now let us move to the illustration. There is a person called as A. Let him be the plaintiff. He is seeking a money decree for breach of contract and damages. A is filing a suit saying that the other person has to pay money to him. He has breached a contract. In this case, the court is saying that plaintiff is entitled to the money decree, or plaintiff is successful. But it gives a further finding that the claim for damages is frivolous. See, in this case, you need to understand the difference. I am saying A has to pay me money. The court says yes, he has to pay you money. No problem about that. And it is giving order in my favor. But the court says I am claiming damages against A. That claiming damage is wrong. In that case, the court will say that I have to pay cost to the defendant. I am successful in this case, but my claiming damages is frivolous and vexatious. Simple thing, if somebody has to give me money, I am asking him to pay the money, he is not paying the money, I am going to the court, asking a direction from the court that he should be directed to pay the money. No problem, it is absolutely fine. But if I am asking for damages, there should be absolute reasons based on which I am asking these damages. If that proper reason is not there, the court can say that my claiming of damage is frivolous and vexatious. Let us move to subsection 3. If the court is planning to impose cost on any of the party, then what things the court should take into consideration, or what are all the circumstances under which the court can make a direction for payment of costs? The first one, the conduct of the parties. That is the first part. The court will observe how the plaintiff is behaving, how the defendant is behaving in a court. That can be a ground for determining the costs. So, if you are a practicing advocate, ensure that the conduct of your client is good in the court if you have to avoid the imposition of cost. The second point what the court will see is whether a party has succeeded. Even if he has partly succeeded, that is sufficient. Just like the example we saw. I may be partly successful. Partly, the court may say, like for example, asking damages, the court may say like you don't have a reason to ask for damage. So it means like partly I have succeeded, partly I have failed. I am not wholly successful. But still the court will see whether I have partly succeeded. The third point, whether a party has made a frivolous counterclaim. For example, let me take that I have given money to some X. That X has not paid the money back. I am filing a case against him. And in that case, the X is filing a counterclaim, saying that no, he has to give me money. That is why I did not pay money. He will simply say, X will say that I have to pay him money. And he does not have any proof for that. He is simply filing this counterclaim to delay the case. That is his intention. In that case, the court will see whether he has filed a frivolous counterclaim. If that be the case, that will also be taken into consideration for determining whether the cost is to be paid or not. And the fourth point, or point D. Imagine a situation, I have filed a case against X. X has to pay me money. X is coming to the court. He is saying, sir, I have to pay you 10 lakhs and interest part is around 3 lakhs. I will pay you that interest part 3 lakhs plus 10 lakhs. And he says, totally I will pay you 13 lakhs. You withdraw the case. But I am saying, no. You have to pay compound interest. Interest is only 3 lakhs. But there is a compounding effect on that interest. You need to pay that compounding effect also. In that case, he will say it is unreasonable. I am paying the interest. I am paying the principal. What else I need to pay? These aspects will also be taken into consideration by the court while determining the cost. And the fifth point, that is E point, is if I file a case against X and that case is a frivolous case or a vexatious case and I wasted the time of the court, in that case also cost will be imposed on the person who has instituted the case. In this case, it will be me. So these 5 points are very important in determining whether a person should pay the cost or not. And in exam, these points may be asked in different formats. You need to remember all these 5 points. And subsection 3. Let us move to subsection 4. Let us try to understand these aspects by way of an example. A has to pay cost to B. This is the order. In this order, the court will say A has to pay 30% of B's cost. For example, B has done some job, due to which the A was bound to pay an amount, and B has incurred cost. In that case, the court will say, out of the cost you have incurred, A has to pay 30%. This is the first point. Proportion of another party's cost. So 30% of whatever cost B has incurred, A has to pay. This is the first point. Let us move to the second point. In other case, for example, B has spent 1 lakh rupee. So the court will say, out of 1 lakh rupee, which B has incurred, the cost which B has incurred, A has to pay, say, 50,000 rupees. Here they will not say the proportion. They will say the amount. This is second point. Third point, costs from or until a certain date. So the court will say, B has incurred cost from, say, 1/1/2020. From that date till 22 you have to pay. So here the court is specifying the duration. That is the third point. In some cases, the court will say the cost has to be paid before the proceedings have begun. Before the beginning of proceedings, he might have incurred some cost. That cost has to be paid by the person who has to pay the cost. Then again, the court will say in certain cases, in the example what we took, A has to pay B cost. So the court will say, B has taken certain steps for the proceedings. For example, he might have got some clearance from the government, or he might have paid some cost to the other parties, connected parties. In all these cases, the court will say that B has spent money for getting government approval. Whatever cost he has incurred for getting that government approval has to be paid by A. The court can say like this. That is the next point. Cost relating to a distinct part of the proceedings. For example, if the case is going on, and in that case, the court says it is going to appoint a commission, or the court is saying, Mr. B, you go and do this job, or you go and do this act, based on which he is doing that act, which is forming a part of this proceedings. In that case, the costs can be specified that A has to pay to B. In this case, the court will specify that the cost which B has incurred for that particular part of proceeding has to be paid by A. And the last part is interest on costs. For example, court is saying A has to pay to B rupees 25,000 on 1/1/2022. In case, if A is not paying this amount on 1/1/2022, court will say, till you pay, you have to pay 6% interest. So this is the last point which you need to understand. If you like the video, please do press the thumbs up button and leave your comments in the comment section. And do subscribe the channel and also share the channel with your friends. Let us join hands together and contribute for a learned society. Thank you.